Welcome to Cramorama. The purpose of this DVD is to help you get through your real estate exam. You can do this. You can pass the test. And this little DVD is going to help you. First, let me give you a couple of tips on how to take the test. Get everything ready the night before and kind of stack it all up on your dresser, including your car keys. You don't want to be getting up at the last minute. You can't find your ID, you can't find your calculator, you can't find your car keys. Murphy is alive and well, and whatever might happen, could happen, probably will happen, and it will happen at the worst possible time just before you're going to go take the test. I don't want you to get there all rattled. Leave early. Get there in plenty of time. If you can't get there on time, show up early. Now, I know that's an old adage, but I want you there fresh. I want you there not rattled and just competent and ready to go in and do that test. When you're doing the test, concentrate on each question and forget about the others. In other words, be in the whole moment with that question as it comes up. It deserves your entire attention. Once you've done the very best you can with that question, forget about it and go on to the next question and progress through the exam that way. The way I like to take the test is to take it with each question as it comes up. And that works for me. A lot of folks like to go through, just do the easy ones and then come back and do the harder ones later. That really depends on you and your personal testing style. A lot of different ways to take it, but you can pass this. I will assure you that this little DVD will help. Now, in front of you, you have a little syllabus. You have a little outline that we're going to work from today. This outline has concepts on it that I'm going to illustrate for you. I'm going to go through them one at a time. If you know these concepts, you will be able to answer the question. Remember, you're preparing for a recognition exam. It's not an exam where you have to know something as much as it is an exam you have to be able to recognize things. Big difference. There are multiple choice questions. You have to choose the correct answer out of a lineup of 4. Now, don't get me wrong, the exam is challenging, but you can do this. And this little tape, this little DVD will help. So let's just jump right into it. We're going to talk about national concepts that would apply to any state's exam. And I've taken many of the state's exams, and let me tell you, this is really going to help. Okay, so due to the nature of assets, what type of investor prefers long-term real estate loans? Well, the answer is insurance companies. Insurance companies put policies in place. People pay premium for a number of years, and then those premium payments come in, and the insurance company knows they're going to have a long-term income stream, so they like to reinvest that in real estate loans. When you're talking about capitalization rate, the cap rate used in evaluation of income property does not take into consideration the federal income tax ramifications of owning that property. Now, most of the ramifications are benefits. We get to write off other income because of depreciation. But cap rate does not take that into consideration. Cap rate is a 1-year snapshot of income for that property while you're operating it. It has nothing to do, or doesn't take into consideration when you sell it 5, 6, 7 years later. It's doubled in value, which is probably the biggest cash flow that property is going to create for you. Fannie Mae, which is the Federal National Mortgage Association, was originally created to provide money in a secondary money market. The government knew that in order to take capital from capital surplus areas and move it into capital short areas, and to facilitate that movement of money, that they needed to develop a secondary market where local lenders could sell their loans to a national or even international presence that could bring money in from all over. So they started Fannie Mae. Fannie Mae was once quasi-governmental and now is totally private. Fannie Mae is the biggest, and Fannie Mae buys all types of loans, FHAs and VAs and conventionals. What must be specifically stated in an option agreement? The length and term of the option. You cannot have an option until, death do we part, or until I decide to buy or not buy. What happens is options must be for a specific period of time. Now, A led C to believe that he worked for B. B approved of A's actions. This would be agency by ratification. Let's say that A was a real estate broker, and they led C to believe, who was a buyer, that they had permission from the owner to sell a particular property. So they're showing a property, a warehouse, a piece of dirt, maybe a house, a condo, and the buyer believed that A was working for B because we gave him access to the property, told him all about it. And A got his authorization from B, the seller, to do this. But you didn't have it in writing, perhaps, and which is always dangerous, by the way. And so you got an offer from the buyer, C, and you took it back to the owner, and the owner said, yeah, I'll do that. They ratified your actions. You have a lot of people that will tell you, well, I won't list it with you, but I've got this property. If you find me a buyer for $500,000, I'll sell it. Well, you do. So you bring them an offer and they sign it most of the time. See, therein lies the danger. You should have a written agreement and talk this over with your broker on whether he wants you to work this way. But we kind of call these pocket listings. Now, 6, what would give constructive notice? Putting something in a public record. So what would not give constructive notice? Obviously, not recording something. Now, a buyer offers to fulfill his part of the contract or does fulfill his part of the contract. What happens is you're tendering the offer. You must do everything you were supposed to do in the agreement so that if it got in front of a judge, it'd be very clear to the judge who the defaulting party was. I mean, if your buyer did everything, including going to the closing and signing all the documents, seller didn't show up, that alone might be prima facie evidence in a court of law that the default didn't occur because of the buyer. If everything was done on a timely basis and they did everything they were supposed to do, obviously the default would very clearly be the seller's. But the buyer tendered the offer. He did everything he was supposed to do. Tenancy means mode of holding. Now, if you're a tenant, that might be periodic tenancy, which would be month to month perhaps, or maybe tenancy for years, which would be a definite duration in time. If you're an owner, it might be joint tenancy. But tenancy means holding, whether you own or whether you're a tenant, whether you rent. Under an exclusive right to sell listing, can the owner terminate the agreement or revoke the agreement? Yes, but they had no cause. If it's a revocation, unilateral revocation, and it wasn't mutually agreed to, the owner could fire the broker, but he would be liable for the broker's expenses and damages. A bilateral agreement is where there's a promise for a promise. Promises are going both ways. And in a bilateral agreement, that alone could be considered consideration. Unilateral is a promise going one way. A really excellent example of a bilateral agreement is the buy-sell agreement between a buyer and a seller, sometimes called conditional sales contract, and many states have their own name for their state form that they're using. A great example of a unilateral contract is an option agreement, because the seller must sell, but the buyer doesn't have to buy. They have an option. Now, should the buyer exercise that option and decide to buy, then that unilateral option became bilateral when it was exercised, and now the promise goes both ways. Could a sale be conditioned upon satisfactory leases being obtained? If you're buying a suburban office building and they have a high vacancy rate, could you make an offer saying, I'll pay this price, but the vacancy rate must be diminished to this area here. I'll accept a 10%, but not a 25% vacancy. So you have to get satisfactory leases that I would approve of, and then we'll go ahead and close on the building. If not, we're going to walk. Of course it could. The contract can be conditioned upon anything, satisfactory leases or inspections or a number of things. Now, the distinguishing characteristics between an option and a conditional sales contract is lack of mutuality of obligation. When I saw this on a test once, I said, whoa, what a great phrase. Lack of mutuality of obligation. Now, when banks sell their promissory notes and loans from one bank to another, or they sell it in the secondary market, they endorse over the promissory note. And there's different ways of endorsing promissory notes. Now, in order for you to really grasp this concept, let's talk about something you're more familiar with than promissory notes. Let's talk about a check. If someone wrote you a check and you wrote on the back of the check just your name, that would be a blank endorsement. You could lose that check. Someone would find it. Whoa, look, it's endorsed. Put their name underneath yours and try to cash it at their local bank. A special endorsement would be you'd write your name on the back and say, pay to the order of your son or daughter or friend that you might owe some money to. That person then would take that check and, it was endorsed over to them. It was a special endorsement. We call it a two-party check, and, banks aren't real fond of them, but there's nothing wrong with it. A restrictive endorsement would be like for deposit only. So you wrote your name and you wrote for deposit only on the check. It restricts what that check could be used for. But a qualified endorsement is where the check was written to you, but you'd endorse it over to someone else, and you could say without recourse. If you put a qualified endorsement that says without recourse, then if that check bounces, it wouldn't affect you whatsoever. Okay. Jones sues Smith in a swimming pool because of a swimming pool accident. Now, the property owner would have levied against him a general lien. A general lien encumbers everything that person owns. A specific lien only covers a specific property. Property taxes are a specific lien. Mechanics liens are specific liens. Mortgages are specific liens. But judgments, IRS tax levies, are general liens. They cover everything that property owner owns. Now, who's exempt from licensing? Well, in virtually all states, anyone that's court appointed, or perhaps someone pursuing a foreclosure, like if it's a sheriff's sale or a trustee's sale, they don't have to have a license. If you use two or more contracts, one which indicates an untrue sales price, that's called a double contract. And the reason why it's being used is to deceive a lender, and of course that's illegal as well. Fiduciary relationship is a relationship where an agent must serve his client's best interest. So fiduciaries are relationships where a client must serve his customer's best interest. Real estate contracts have four essential elements. They are mutual consent, capacity, consideration, and lawful purpose. Have an excellent feel for those because they're very important. Mutual consent, capacity, consideration, and lawful purpose. If they're all there, the contract is valid. If one of them is completely lacking, the contract is void. But often you'll see a contract where it was valid but became voidable. For example, if a purchaser bought a home, put it under contract, the seller accepted it, so now we call that under contract, then you have a situation where you have a valid contract. However, if the house burns down prior to the settlement and closing, then what happens is that contract became voidable. Some contracts are voidable right from the beginning, and usually this is because you have a part of one of the essential elements. They're favored on the exam as an adult and a minor that enter into a contract together. The adult has capacity, but the minor does not. Therefore, that contract is not valid, but neither is it void. It is voidable from the beginning. So have a good feel for those. Written permission is required before you put up a sign in virtually all states, and written permission is achieved, of course, when you get a listing, and in that listing it says you can put up a sign. You must disclose when buying and selling your own investments. You understand that. When you become an agent, the courts consider that you have superior knowledge, and you have to let people know when you're leasing, whether you're a landlord or a tenant, or whether you're selling. Either you're the seller or the buyer, you have to let people know that you're an agent. You must submit all offers, and they must be submitted promptly. Even though you know the seller isn't going to like the offer, all offers must be presented. Reg Z gets its authority from the Federal Consumer Protection Act. Reg Z is also called Truth in Lending. Truth in Lending provides that you can always advertise the APR. It's one of the things that it actually created was the APR. But you cannot advertise an interest rate that is not APR. The nominal or face rate alone, you cannot advertise that unless you give all the other terms of the loan, including down payment, monthly payment, and whatnot. So Truth in Lending prohibits the use of 9% without indicating all details of the loan. Unless it said 9% APR, then that would be okay. Loans made to corporation are not covered by the Real Estate Settlement Procedures Act, RESPA, because RESPA is a consumer protection law, not something set up to protect corporations. RESPA requires the use of the HUD settlement statements. Now, civil rights include both real and personal property, but some homeowners may be exempt from, for example, the Federal Fair Housing Law. If you own 3 or fewer units, then you can be bigoted in your choice of a tenant, but you cannot advertise that way. So that's, euphemistically we call it the Mrs. Murphy exemption. But if you own 3 or fewer units, you could violate someone's civil rights and get away with it. HUD takes a dim view on this, however, and they'll let you do like 1 discriminatory act a year. But your test says that there are exemptions to federal fair housing. The other 2 exemptions are quite easy. One of them is a religious organization renting only to their own members because they have apartment that's somewhat subsidized by the gift offerings, the free will offerings or tithes of their members. Another is a private club can rent to only their own members as well. So 3 or fewer units are those other 2 exemptions. Those are the exemptions to federal fair housing. A broker should withdraw if the owner insists on them in violating the law. If you have an owner that lists a property but they say, I don't want any Irish people applying to buy this property now, no Irish need apply, obviously that would be discriminatory on national origin. You can't do that. Define exclusive right to sell. Your broker gets the commission no matter who sells a property. Exclusive right to sell is a listing that no matter who sells it, including the owner themselves, the broker always gets paid. Now, a moment ago I talked about a double contract where we deceived a lender with a false sales price. Maybe they lent more money on that property than they ordinarily would have. When this whole deal unravels and the property goes into default, which they often do, the seller, because there was kind of a conspiracy here, the seller is liable for civil action. That lender could sue that seller. Brokers may be brought before a hearing, of course, for disciplinary action, and you will, and you'll lose your license for that. Under federal fair housing, there was a landmark Supreme Court case that was the first that really vindicated or held that a Title VIII could actually be used, and that landmark case was Jones versus Mayer. So 1968, Title VIII, federal fair housing, was put into play, and pretty soon thereafter we had a Supreme Court case that kind of interpreted that law and upheld various aspects of it. You don't have to know exactly what Jones versus Mayer does or did. You just have to know that Jones versus Mayer had something to do with fair housing. The Federal Fair Housing Act of 1968 applies to single residences, duplexes, fourplexes, etc. It covers race, creed, color, religion, sex, national origin, and as amended in 88, also handicapped and familial status. If you have obtained a judgment against someone, you've won in a court of law and have received that judgment, they're not paying you, you can go back into court and ask for a writ of execution, which would in some way enforce that judgment. Writ of execution could be the first step on foreclosure if it was a property. A constable could get involved or other court officer in seizing property and selling it. Nasty stuff, but enforcing a judgment would be done with a writ of execution. What would make a deed void? Well, making it to a fictitious grantee. Now, a fictitious grantee would be like Mickey Mouse. Sorry, I don't want to burst any bubbles here, but Mickey doesn't really exist. So you could write a deed and have it filled out and put the property into a fictitious name. Someone could have an alias. Getting it into their name, into that name is not going to be hard at all. Getting it out is going to be a real challenge. But you can't make a deed out to Mickey Mouse. It doesn't work. Contract best defined as a deliberate agreement based upon legal consideration between 2 or more parties who have capacity to perform or to abstain from doing a legal act, to do or not to do something. So, a pretty long definition of a contract. Sounds pretty good. Just have a feel for that. The relationship of a thing desired to a potential purchaser is defined as value. Value. People will pay something for something because of a future perceived benefit, usually. An agreement to create agency to sell real estate requires a written contract. Most states' statute of frauds cover listing agreements as well. And you cannot enforce your commission if you don't have a written agreement. So, your broker's going to be really miffed with you if you don't get written contracts. You must get written contracts. Most states also have the fact that you did verbal agreements in their standards and practices, and so it'd be a license violation as well. Through negligence, A led B to believe that C was his agent. Now, let's say that A is a builder, and he had someone show up on site, and he's showing him through the property, and he keeps referring to, well, my broker, my agent, my broker, my agent. Now, the reality is he hasn't signed a listing agreement yet on this property. Maybe it's in a new subdivision, he's listed 3 or 4 with this agent, but not this 5th house. But he keeps talking like he had. So the consumer believes that, well, C really is the agent. In fact, A told C, go ahead and call my agent, they'll prepare an offer and they'll get everything put together. So even though there is not a written agreement in place, this is called ostensible authority, because it is the builder telling the consumer, yeah, call my agent. That's ostensible or apparent authority. Now, when you take the offer back over to the builder that the buyer has put together, then of course you take a listing agreement with you at the same time. If you're going to do a subdivision, the very first thing you should do as a subdivider is to analyze the market. Is there really a market for additional lots in this community, whether they're commercial, industrial, or even residential? You don't want to be putting millions of dollars into the dirt and on top of the dirt and improvements and inside of it for sewer and water and whatnot, and then find out that nobody wants to buy your lots. You analyze the market first. A net lease provides net income to the lessor. Now, on your real estate examination, they make it real easy. A gross lease is any lease where the landlord pays any expense whatsoever. So if landlord receives income and he pays anybody for anything, taxes, water bills, insurance, maintenance, whatever it might be, that's gross. It's a gross lease. Landlord pays nothing net. Landlord pays nothing net. Anything gross, nothing net. Personal property has a distinguishing characteristic, and that is mobile. It moves from one place to another. Your automobile has wheels, it moves around, and that makes it personal property, but your home does not, unless it does, in which case if your home does move around with wheels, then it's not real property, it's personal property. Now, once again, what is the best example of a unilateral contract? It is that option agreement, isn't it? But if it's exercised, then it becomes bilateral, doesn't it? Okay. In regards to appraisal, let me cover a couple of things here. Appraisal is a real important topic for the test. Have a real good feel that every appraisal needs to have 3 approaches to value in it. And the approaches are, of course, market data, income, and cost approach. Market data, income, and cost approach. Not necessarily in that order, depends on the form, but all appraisals must have 3 approaches to value in it, or it's not an appraisal. Okay, the word depreciation, when used in an appraisal, does not mean some tax write-off. That's the IRS way of looking at it. Appraisers are real life people. They don't have big boots and storm around in uniforms. Sorry, IRS agents. But anyway, what happens is appraisers deal with reality, not fuzzy thinking tax loophole concepts. Okay, so what happens is depreciation, when it's used in context with an appraisal, means specific things. It means functional obsolescence. Functional obsolescence is poor floor plans. We kid around and say, well, these are houses designed by men. It could be economic obsolescence, which is real smelly things in a neighborhood, that kind of thing. Or it might be physical wear and tear, deferred maintenance, peeling paint, things like that. What's an endorsement? Well, title insurance has something on it that lenders like to buy additional coverage, they're additional riders to a policy. These are called endorsements. They're very common, inexpensive, usually under $100 or so, but it ensures the lender that the common address is okay, there aren't radioactive mill tailings all over the site, and that there's no mechanics liens. They have like 3 different things they put on there, and they're called endorsements. So be aware, if you're asked how much did a buyer pay for title insurance, and it says including endorsements, and you're looking at a settlement sheet, that's going to be another line item that you're going to have to find. Okay, could a listing be terminated with mutual consent of both people? Well, of course it could. And another item that's good to know is that the word limited partnership will rarely be used in a test question, but they might use the word syndication. So a passive investor who invested with the syndication would be considered a limited partner. But no devious examiner is going to use the word limited partnership, because then you'd figure it out. Land description. The most popular land description question is that every meets and bounds description has a point of beginning. Every meets and bounds description has a point of beginning. Well, those are some concepts I know you're going to see in the test. I hope they're very helpful to you. Thanks for watching, and as always, if I can ever be any help to you, don't hesitate to get a hold of me. You can reach me at rickroller.com. There's a contact button there, or you can just email me at rick@rickroller.com. Thanks for watching, and best of luck to you.